Give me just a second to pull up. All right. Good morning, sir. How are you? Good. And you're Mason Krooks? And Mr. Krooks, you're on probation for theft of property, a third-degree felony. And I received an administrative hearing. Give me just a second to remind myself.
Okay. Right out the gate, we're dealing with a probationer who's already skating on thin ice. Theft of property, family assault, and now he hasn't even been checking in. The judge's patience is about to expire, and you can feel it coming.
You've been charged with, it looks like another offense of assault, family violence maybe. Is that correct? But it looks like they're not pursuing that. Is that still the position? And then not reporting online or by mail to Jefferson County for several months.
I have a social.
So
My wife got a vehicle over the week, so I'll be able to start doing more community service.
are you working? Why aren't you working? So do you not live anywhere where you could get to a job?
I have job applications out for the tire shop by our house to where I can work now between 7 and 2 before my wife goes to work first, and then we haven't had a vehicle about it has, and you can ask Mr. Bro, it has been a problem.
You owe so much money. I mean.
I think the thing of it is, Judge, is that Mr. Krooks, he's been on probation for 2.5 years now, being courtesy supervised over in Orange County, and he seems to be coming up with every excuse in the book. And Orange County is just at the point where they're just tired of dealing with it, and they're...
Notice what the probation officer just did. He basically threw this guy under the bus. When officers start saying every excuse in the book, it's game over. Judges hate repeat. Excuses more than missed court dates.
almost ready to return his case back to Jefferson County. Based off of the offense, that is his uncle.
Right.
And so we submitted an order of amended conditions, so just
the no contact. I got that. Have there been any other issues since the no contact, since that was signed?
So not since the no contact was signed. Had an issue with walking by the uncle's house, and the uncle called into the probation department over in Orange County, reporting them saying that he's taunting or whatnot. And I advised Mr. Krooks to take another route instead of just going by there.
How far apart do y'all live?
I live in Mauriceville. He lives in Orange.
So why would you have been walking by his house?
I had to walk through the neighborhood to get to my direction of home.
From Orange to Mauriceville?
Yes, ma'am. All the houses were instead of 62, 16th Street. I went through all the neighborhoods.
I bet there's any number of other ways that you can go if you're walking from Orange to Mauriceville instead of in front of your uncle's house, who we're having all these issues with.
Here's where it gets intense. The judge is spelling it out. You mess up again, that's 2 to 10 years in prison. You can almost see her drawing the line in the sand. Zero tolerance. Question for you guys. Should a probation violation ever get that harsh of a warning? Or is she being too strict?
Do you understand? Well, but you keep making mistakes, and your mistake's going to cost you potentially 2 to 10 years in prison, because this is going to be the last time we're in court talking about this, all right? One more call about you walking by a house, showing up somewhere where they are, sending a message, whatever it is, however it is, then you're going to be back in here, and I'm going to ask your probation officer to file an MTRP. If you're not paying the money and we're not getting the victim of this paid back, then you might as well be sitting in prison. So it's time for you to get busy. You've been on probation for 2.5 years, and from this point forward, it is not going to go like it has been. There's not going to be an excuse for everything. Figure it out. Walk, get a bicycle, get a job, and start making payments. I don't care where you're working. Get a job. Figure it out. Make a budget. I want that done quickly. I want you to have a job quickly, and I want you to start making payments, because what happens is if you don't start doing everything you're supposed to, Orange is going to send your case back to Jefferson County. If they do that, 2 options. 1, a motion to revoke your probation because you can't do what you're supposed to over there. 2, you're going to have to come over here and report and do everything in Jefferson County. So if transportation and all of that's an issue with just getting around locally, it's going to be a big issue if you have to come back here.
And just like that, case 1 wraps with a warning and a wake-up call. But buckle up. The next defendant walks in, facing aggravated assault with a deadly weapon. Yeah, we just jumped levels.
All right, this is it. You're on zero tolerance at this point. Get it all taken care of, or you're going to be right back in here. All right, thank you. Thank you, sir. You're free to go.
I'm gonna borrow some time, but I can't tie it.
It's all right, you're good. All right, are you Maverick Neil? And Mr. Neil's charged with aggravated assault with a deadly weapon in 24 DCCR 2436, and what is the announcement?
Judge, we'd reset for me to try to contact the complainant. I'm not getting any answers for written correspondence or the different phone numbers my investigators know to locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we're set for trial, and I'll could double our efforts to locate her.
And you intend to go forward with or without?
I believe I can prove the case without her presence, Your Honor.
Okay, so if, sounds like there needs to be a rejection done, if there's not going to be, if he does not want to accept any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
All right, so Mr. Neil, in cause number 242436, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, I do.
And I have here on the computer a plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your case, for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. And with that type of probation, if you successfully completed it, the case would be dismissed and you wouldn't have a felony conviction. Do you understand? So
This is a pivotal moment. The defendant just rejected a plea deal for 5 years of deferred probation. Translation: he could have walked away without a felony. Now, if he loses at trial, he's looking at up to 20 years. That's the difference between freedom and a decade behind bars.
So I want to make sure that you do understand everything, because it's very important that after today, if I put your case on the trial docket, I won't accept this plea agreement. All right, so if you want the plea agreement, fine. If you are not guilty and you want to have a jury decide, that's fine as well. Mr. Nichols has stated earlier today that he intends to go forward with or without the complaining witness in this case. So we've talked about that. I don't want you to think that at some later date he intends to dismiss the case or something would change unless there's new evidence that comes forward. So if you don't want to take this 5-year deferred probation, that's fine. We'll put it on the trial docket, but I want you to make sure you understand that I will not accept this agreement after today. If you change your mind later and you want to enter a plea of guilty, then you can plea open to the court or to some other plea agreement. Do you understand that? And do you want to reject that plea agreement and have your case set for trial? It's your decision.
Sorry.
I mean, go ahead. I mean, if y'all need to talk some more, but
You don't want to plead, correct? Yes, you want to plead, or no, you don't want to plead? That's what we've been talking about outside.
so you've been talking about it with Mr. Doyle.
Because I'm not understanding
What are you not understanding?
it's been 4 times, right?
I don't know about 4 times.
He's talking about the docket calls.
Okay.
The state had indicated to me that they might have, or I indicated to the state rather, that the victim didn't want to prosecute the case.
Right.
He's never been able to get a hold of the victim.
Right.
To have her tell him that. He feels like he's been up here enough that I have the authority to make the state dismiss it, and I don't.
No, correct. So Mr. Doyle is doing everything he can with trying to negotiate with the district attorney. And it is legally possible for the state to go forward with a case without the complaining witness, and that is what they intend to do, according to Mr. Nichols, correct,
Yes,
Mr.
sir.
Nichols? So with or without her, they're going to present the evidence that they do have to a jury if you go to a jury trial, and then that jury can decide whether or not you did or didn't do what they're charging you with. So today is the day to decide if you want to go to trial and let that jury decide whether she comes or not, case isn't getting dismissed, or if you want to enter a plea of guilty to the offense for that 5-year deferred probation. So you want to have a jury decide. Then I will place your case on the trial docket. Mr. Dole will begin preparation for trial.
Okay, do you have any ideas?
They'll send you that date. We're about
Okay.
3 months or so.
Okay.
Okay. Yes, sir. Thank you. You're free to
Thank you,
go.
Your Honor.